Greetings and welcome to Constitutional Law, Nature of Police Power from American Jurisprudence. So, what we have here today is to go over some of American Jurisprudence, second edition, Constitutional Law, and we're going to be starting on section 333, which is police power. And from here, we also have Black's Law Dictionary, close at hand, 9th edition, to make sure we leave no word behind. With that said, I would like to start up with the general here, definitions, source of power. So, police power is a general term used to express the particular authority of a government to act, which belongs to every sovereign government. It is an inherent attribute of the states. Thus, the police power is now more commonly termed the state's regulatory authority, and is essentially the power to govern. The, quote, police power, unquote, of the state is best defined on a case-by-case basis. So the observation we have here, a definition of police power is essentially the product of legislative determinations addressed to the purposes of government, purposes neither abstractly nor historically capable of complete definition. According to some authorities, since the police power simply refers to governmental action not precluded by any specific provision in the federal or state constitution, it has little or no useful meaning. So, when you say something like police power, simply refers to governmental action and it's not precluded by any specific provisions. So, that's where the definition of a word like police power is a little bit hard to address directly here, but we're going to do the best we can. The police power cannot be circumscribed within narrow limits or confined to precedents resting alone on the conditions of the past. The term police power is difficult to define precisely because it is extensive, elastic, and constantly evolving to meet new and increasing demands for its exercise for the benefit of society and to promote the general welfare. A state's police power has been described as the power of the legislature to make such regulations relating to personal and property rights as appertain to the public health, the public safety, and the public morals, as the legislature's broad inherent power to pass laws that promote the public health, safety, and welfare. As the power vested in the legislature by the Constitution to make, ordain, and establish all manner of wholesome and reasonable laws, statutes, and ordinances. Notice how we have different words here for laws, statutes, and ordinances. Either with penalties or without, not repugnant to the Constitution, as they judge to be for the good and welfare of the state and of the subjects of the same. Subjects isn't a really good word to be using here, but we'll see what this footnote 12 is. Let's take a brief reprieve and see what they're referring to here. This is Nye versus Town of Emerald Isle, North Carolina, 2015. Interesting they use the word subject in there. But that being said, before we go any further, I just want to remind everyone that this is strictly for entertainment, educational purposes only, not for professional, personal, or legal affairs. Don't consider this any kind of legal, lawful, professional, financial advice in any way, and don't do this at home. That being said, I want to say greetings to everyone that's here. Audit them. Indeed, class is in session. And if anyone else is here, please hit the like so we can get the word out for more people to learn about some of the foundations of our judicial system here and our constitutional form of government. All right, let's proceed here. So, as a state's inherent power as a sovereign to enact laws to promote the health, peace, morals, education, and good order of the people, and to legislate so as to increase the industries of the state, develop its resources, and add to its wealth and prosperity. And as the ability of the state to impose restraints on private rights that are necessary to the general welfare. The ability of the state to impose restraints on private rights that are necessary to the general welfare. The police power is not a grant derived from or under any written constitution. It is an essential element of the social compact, footnote 16. That's New Jersey Shore Builders Association versus Township of Jackson, 2009 in New Jersey. Thus, the states vested, as they are with the general police power, require no specific grant of authority in the federal Constitution to legislate with respect to matters traditionally within the scope of police power. The term police power is not found in the Declaration of Independence, the federal Constitution, or even in most state constitutions. That's footnote 18. That's Myers versus City of Defiance, Ohio, 1940. The police power is as old as civilized governments that exercise it. The states existed before the Constitution of the United States, and they possessed the police power before the adoption of that organic document. The states require no specific grant of authority in the federal Constitution to legislate on matters that are traditionally within the scope of police power. Moreover, the Constitution supposes the pre-existence of police power and must be construed in that light. Footnote 21, another case here, Little Rock, Arkansas, 1956 and 1953. That one was in West Virginia in 56, and Arkansas 41, North Dakota 53. The police power is a grant from the people to their governmental agents. A grant. So if we look up the legal definition of grant, one moment here. And we're going to transition over here to blacks so that we find out exactly what they mean by a grant. Because there's gifts, there's grants. And this is not the best way of scanning through here on this digital document, but it'll get us to where we need to go. Appreciate the patience. This is why I like to thumb through a hard copy of Black's Law. Yeah, we're almost there here. It's just taking some time. We're almost there. Here we are. Great. So grant. Here we go. the act of granting. So it's a verb, grant, verb, transitive, 13th century, to give or confer something with or without compensation. To formally transfer, well, real property by deed or other writing, to grant property, right? To permit. Grant is to permit or agree to approve, warrant, or order. That's a grant, a request motion to grant, to approve. So now we have a good background of grant. And let's get back to the article here. All right, so the police power is a grant. It's approval from the people to their governmental agents, and is the practical manifestation of each individual's agreement as part of the social compact to subject that individual's rights to the common good in cases of conflict. Ooh. The right of the legislature to exercise the police power is not only not referable to any single provision of the Constitution, but also adheres in and springs from the nature of our institutions. So it is not only not referable to a single provision, but it also adheres in and springs from the nature of our institutions. The constitutional notion of the police power does not refer to an independent source of legislative power itself, but merely represents the legislature's general plenary power to legislate, and that's your absolute power to legislate. The power of the states to enact and enforce criminal laws is constitutional in nature. The states possess primary authority for defining and enforcing the criminal law, and the administration of criminal justice resides within the states, except as Congress has created offenses against the United States. The authority to formulate and enforce penal sanctions is an important aspect of the sovereignty retained by the states. Thus, each state's power to prosecute is derived from its inherent sovereignty, not from the federal government. All right? And it looks like we get through all these footnotes that we needed to. They're all just citations of cases. Sovereign states have strong interests in formulating and enforcing their own criminal justice systems. And that was, 2016. All right, we're on to section 334. Nature of police power, generally. The police power is an indispensable and essential attribute of sovereignty. It's not a principle, but it's an attribute of sovereignty. Notice, indispensable and essential attribute. Notice the difference between principle and attribute. This is an expression of its principle of the sovereignty, and has been said to be an inherent attribute of the states. The police power is plenary in scope, again, absolute in scope, and is a necessary feature of every civilized government. It is one of the most essential and least limitable powers of the states. An act is within the state's police power if it is reasonably related to a legitimate governmental interest, even if the authorities have treated such conduct as grand old traditions and turned a blind eye in the past. Wow. Practice tip: because a law adopted in the exercise of the police power is presumed constitutional, its challenger bears the burden of affirmatively and clearly establishing its invalidity. Law adopted in the exercise of police power is presumed constitutional. Pay attention to this. If a law is adopted, it is automatically presumed constitutional. So if you're going to challenge a law of police power and on its constitutionality, that you'll have the burden of affirmatively and clearly establishing the invalidity of the so-called police power that is presumed constitutional. You're going to have to break away that presumption. And that was footnote number 9. 1993. Wow, so this is commonly held here. Wow, 94, 90. Important practice tip. I'm not saying that this is a finality as far as the way to look at something like this, but the presumption is going to be there if you're ever challenging a police power. And if there's going to be any effective challenge, that presumption of constitutionality needs an affirmative challenge to establish the invalidity and clearly establishing it. A difficult hurdle, legally speaking, however, as the exercise of police power by the states. Okay, let's continue here. Section 335. Yeah, there's nothing else here, right? Yeah. Distinctions between police and other governmental powers. The boundary line dividing the police power of the state from other functions of government is often difficult to discern. For example, although its exercise and the exercise of power of eminent domain have much in common, the police and eminent domain powers are also essentially distinct. Thus, under the police power, many kinds of restrictions may be imposed without compensation being given, whereas under the power of eminent domain, compensation is required. Private property is taken by eminent domain for a public use, while the police power regulates in the use and enjoyment of property. The mere assertion of regulatory jurisdiction by a governmental body does not constitute a regulatory taking of property for eminent domain purposes, as all property is held subject to the valid exercise of the police power. Eminent domain is something that is another important issue to pay attention with, considering the way property is sometimes seized and occupied. As to the power to tax, there is a genuine distinction between the police power and the state's distinct, coexistent authority to levy taxes. The basic difference is that the taxing power is exercised to raise revenue and is subject to certain designated constitutional limitations, while the police power is exercised to promote the public welfare and is not subject to the constitutional restrictions that apply to the taxing power. If the primary purpose of a statute or ordinance is to raise revenue, it represents an exercise of the taxing power. Did you get that? If the primary purpose of a statute or ordinance is to raise revenue, it represents an exercise of the taxing power. So, if you're cited for a statute, and it seems that the primary purpose of that statute is to gain revenue, to raise revenue, then it legally represents an exercise of the taxing power, and it'll have certain constitutional restrictions that would apply. While if the primary purpose is to regulate some particular occupation, Calling or activity. It is an exercise of the police power, even if it incidentally producing revenue. Oh, of course. Number 12. Let's see. 1924, 1931, 1943. Okay, so very interesting here. But to know this distinction here is very important to know. The coexistent authority to levy taxes, there's a basic difference and a simple test is written right here. If the primary purpose is to raise revenue, it represents the exercise of a taxing power, while if the primary purpose is to regulate some particular occupation, calling, or activity, then it's an exercise of police power, and even if it incidentally produces revenue. The war power of Congress is not unlike what in the states is called the police power. The war power of Congress is not unlike what the states call the police power, but it is the police power raised to the highest degree. Interesting. So police powers are a ratio of war power. The war power preserves sovereignty, while the police power preserves the health and morals of the community. The state's power to effect extraordinary regulations in emergencies is less extensive than the war power of the federal government, as a regulatory authority is confined to the scope of the police power itself. Again, police power preserves health and morals of the community. Footnote 14. Okay, it's 1921. Interesting here, though, that the war power and the police power being equated here in just by difference of degree. Powerful stuff here. Let's continue down to section 336, flexibility of police power. The police power is a continuing authority that is quite broad and comprehensive, which is to be liberally construed and applied. The police power of the state is capable of development and modification within constitutional limits to allow the powers of governmental control to meet changing social, economic, and political conditions. Now, all these words are very powerful when it comes to maxims of law. And remember that this is a term of art we're working with here, police power, because it's not written, it's not defined, it's not referred to in the Constitution, the Declaration of Independence, or most state constitutions. So let's continue here. Thus, the police power is not confined within the narrow circumspection of precedents, resting upon past conditions which do not cover and control present-day conditions. So looking at past precedent isn't going to help establish the conditions of today and the needs for those conditions of today. Obviously calling for revised regulations to promote the health, safety, morals, or general welfare of the public. Revised regulations. As a commonwealth develops politically, economically, and socially, the police power likewise develops, within reason, to meet the changed and changing conditions. A legislature need not deal with every problem at once. It must be afforded a degree of leeway in tailoring the means to the ends. Nice. Thus, in exercising the police power, the legislature may proceed step by step, condemning that which it deems to be the greatest menace to the health and welfare of the people, and leaving further regulation and prohibition for future consideration. Similarly, on the local level, the federal Constitution does not require a city council, for example, to enact a perfect law. The council may proceed step by step, adopting regulations that only partially ameliorate a perceived evil, and deferring complete elimination of the evil to future regulations. So to have an escalation here or a increasingly incrementing approach to solving a problem. Without the presence of some circumstances to induce heightened judicial scrutiny, a court is entitled to presume that a municipal ordinance is valid. Court is, okay. Without the presence of some circumstance, so think about this, some circumstances to induce heightened judicial scrutiny. So think about this. What circumstance would induce a heightened judicial scrutiny? A court is entitled to presume, without that, a court's going to be entitled to presume that a municipal ordinance is valid and is not required to delve into the motivations of the board members who proposed and drafted the ordinance. Some circumstances. Okay, presence of some circumstances. Can't be conjecture or hypotheticals. There must be a presence of some circumstances that would induce the heightened judicial scrutiny. All right, again, we're back to the presumptions that you need to focus on because that's going to be the first thing you come up against. Let's see here. We get some, let's answer the chat here. Yosef L here says, I'm new to the channel. Do you have a chat room or another place to talk? Not really. I just pretty much put this out here, and I like to do the live streams because this is a good place for us to talk and share with everyone out there that's spending the time and has the wherewithal to learn some of these foundations of our common law and American jurisprudence. You're welcome to throw any questions right now in the chat, and you'll get my opinions in response. And we could also delve into the documents we have here if we need to get more facts. All right, that being said, again, the presumptions are the first thing to address. So let's go to our cumulative supplements here, the cases. That the police power retained by the states empowers state officials to address pandemics such as the COVID-19 largely without interference from the courts is especially true where a party seeks emergency relief in an interlocutory posture, while local officials are actively shaping their response to changing facts on the ground. All right, let's break this down a bit. This is a 2021, this is our supplement here, is a 2022 supplement. So it's got some pretty current cases here. The police power retained by the state empowers state officials to address pandemics such as the COVID-19 largely without interference from the courts. Is especially true where a party seeks emergency relief in an interlocutory posture, while the local officials are acting. So this is to changing facts on the ground. Oh, Lord. All right, so this is Southwestern Ohio Basketball Incorporated versus Himes Ohio Court 2021. All right, so I'm not too sure about that case there. Something worth looking into. I don't think that's going to... A state's police power is truly a thing of vitality and reality. And it is a power that is both broad and useful. 1947. The police power of a state is comprehensive and reaches nearly every aspect of civil society. All right, we're on to section 337, Inalienability of police power. The state may not surrender, abdicate, or abridge its police power. Any attempt to do so is simply unenforceable. It is a fundamental principle of constitutional law that in matters relating to the police power, each successive legislature is of equal authority. Thus, a legislative body cannot part with its right to exercise that power, since it inherently has authority to use the power again and again, as often as the public interest may require. The state cannot barter or bargain away the right to use the police power, either through contract or by enacting a law that cannot be repealed. Wow. Barter away or bargain away. Thus, an entity whose rights are subject to state restriction cannot remove those rights from the power of the state by making a contract about them. Wow. The discretion of the legislature with respect to exercise of the police power cannot be parted with any more than the power itself. A municipality cannot, by contract, foreclose the exercise of the police power unless clearly authorized to do so by the supreme legislative power. Wow. That's footnote 11, 1908, 1922. Gas and Power, Telephone and Telegraph Company. Oof. Well-established law there. Municipality cannot, by contract, foreclose the exercise of the police power unless clearly authorized to do so by the supreme legislative power. A state that embodies a legislative attempt to surrender or limit the state's police power is unconstitutional and void. However, the inalienability of the police power does not preclude its delegation to municipalities and other governmental subdivisions, as those entities are part of the total government of the state. So it doesn't preclude a delegation to municipalities. So a state that embodies a legislative attempt to surrender or limit a state's police powers is unconstitutional and void. But the inalienability of the police power does not preclude its delegation to municipalities. So it's funny how that are part of the total government of the state, that state police powers can be delegated to municipalities and other governmental subdivisions is odd. Footnote 13, 1988, 1994, City of Board of Commissioners of Orleans Levy District, and People versus Weinberg. All right, so interesting cases. We've been there for some time now. Let's look at this observation here. When a legislative body retains the police power, articulated standards and guidelines to limit the exercise of that power are unnecessary. However, police powers that are delegated must include minimum standards and guidelines for their application. Nice. So when a legislative body retains a police power, articulated standards and guidelines to limit the exercise of that power are unnecessary when a legislative body does it. But when they are not part of a legislative body like a municipality, then there must be minimum standards and guidelines. Got those? They're very important terms here. Minimum standards and guidelines whenever those powers, police powers, are delegated to a municipality or other, what do they say here? Governmental subdivisions. Yikes. All right, powerful stuff here. 1997 on that one. And we're on to section 338. Police power as a law of necessity. The police power has been described as being coextensive with the necessities of the case and the safeguards of the public interest. In a general way, the police power extends to all the great public needs. Thus, governments may undertake to do more than the Constitution requires. For example, a law requiring all automobile drivers to have mandatory insurance coverage is within the state's police power. It is not essential that a person present necessity. It is not essential that a present necessity exists before the legislature exercises its police power, as it may act to prevent apprehended dangers as well as to control those that already exist. So, a law requiring all automobile drivers to have mandatory insurance coverage is within the state's police power. Let's see, 1994, badge number 153. Yeah, right. So we have here Fifth Circuit. Holding that a state statute requiring proof of automobile liability insurance is not unconstitutional on the ground that no federal law or constitutional provision addresses the issue, since the state has authority to create and enforce such laws and regulations under its police power. So that's the argument. So this was a bad argument is what it was. Holding that a state statute requiring proof of automobile liability insurance is not unconstitutional on the ground that no federal law. So that's the wrong ground, that no federal law addresses the issue. So that's why that is here saying this example. A law says is within the state's police power. It's not saying that necessarily there has to be a law for that, or there can be, but it would be within their power to do that, and then it could be challenged. It is not essential that a present necessity exists before the legislature exerts its police power, as it may act to prevent apprehended dangers, as well as control those that already exist. Although an emergency does not create power, increase a granted power. Remember we talked about the granted power? So emergency does not increase the granted power, increase the allowance of that power, or remove or diminish the restrictions imposed upon a power granted or reserved. An emergency may furnish the occasion for the exercise of police measures. It must be borne in mind, however, that an emergency does not automatically remove all constitutional restraints. Accordingly, a law that depends on the existence of an emergency to uphold it may cease to operate if the emergency ceases, even though it was valid when it passed. So a law depending on the existence of an emergency to uphold it may cease to operate if the emergency ceases. It's footnote 8. 1934, 47, 44, 45. All right, and we are on to section 339, authority of states and political subdivisions to exercise police power. Quote-unquote police power is the authority of the state and its political subdivisions to impose restraints on private rights as necessary for the general welfare. The police power, under our constitutional system, has been left to the states and is normally vested in and exercised by the legislative branch or by political subdivisions of the state, to which the legislature has made a proper delegation of its authority, as we spoke of earlier, the delegation of police powers, which would require the minimum standards. Although a state may not surrender, abdicate, or abridge its police power, the authority may be delegated to municipalities and other governmental subdivisions, as these entities are part of the government structure of the state. The power is vested in the state and flows to the locality through a legislative grant, allowance again. Both the state and its municipalities have a wide discretion in resorting to police power for the purpose of preserving public health, safety, and morals, or abating public nuisances. Thus, the government, through its police power, may promulgate ordinances to promote the health, safety, morals, or general welfare of its citizens. So the government may use police power to promulgate ordinances to promote the health, safety, morals, or general welfare. To promulgate, to make it prominently known. The police power has always belonged to the states, and it was not surrendered by them to the general government or directly restricted by the federal Constitution. The provisions of the federal Constitution elevating federal treaties and statutes over state legislation apply fully to state police power regulations. Federal treaties and statutes over state legislation, like diplomatic type of stuff, would apply fully to state police power regulations, right? To regulate them. And thus, the police power of state does not embrace a subject that has been vested exclusively to Congress by the Constitution, nor can it defeat or impair a statute duly enacted by Congress. Okay, that's good. Let's look at these footnotes here. The police power of the Commonwealth, this is Minnesota. In the context, is it? No, Virginia. Sorry, Virginia. The police power of the Commonwealth, in the context of the constitutional provision prohibiting the abridgment of that power, is best described as a Commonwealth's inherent power, as a sovereign, to enact laws to promote the health, peace, morals, education, and good order of the people, and to legislate so as to increase the industries of the state, develop its resources, and add to its wealth and prosperity. Okay, holding that the inalienability of the police force does not preclude its delegation to municipalities and other governmental subdivisions, as those entities are part of the total government of the state. So again, the delegation, and then if you are challenging a delegation, then knowing those minimum standards and requirements, right, which would have to be somehow expressed or written. As to the exercise of the police power by municipal corporations, see AmJur municipal corporations, which, by the way, when we talk about what powers are delegated, they have to be expressed and written. So a public information request or a public records request to any municipality should have some type of contract or terms of their minimum standards that their police powers were delegated by the legislature, because a municipality has no police powers inherently. They must be delegated by a state authority, according to what we've been reading here. So it'd be interesting to see, being that that delegation of authority requires minimum standards, which would have to be documented somewhere and expressed in that document, which would be a public record. So that's one for the FOIA exercise if someone wants to do that. Section 340. Authority of states and political subdivisions to exercise police power. Exercise by legislature. The police power of states is generally vested in and exercised by the legislative branch of state government. The power of the legislature is extremely broad and is subject only to the requirements of reasonableness and appropriateness of the means and to the limitations of the federal and state constitutions. Within constitutional limits, the legislative branch is the sole judge of laws that should be enacted for the protection and welfare of the people, and of when and how the police power of the state is to be exercised. However, a legislature may not, under the guise of regulating in the public interest, impose conditions that are facially unreasonable, arbitrary, discriminatory, or confiscatory. Nice. Nice language here. And this is all under political subdivisions, the authority of the political subdivisions to exercise police power. And this one is exercised by the legislature. So that's where our police power is vested, by the legislature in states. So here we have one from Wisconsin 91. It is for the legislature to determine what regulations, restraints, or prohibitions are reasonably required to protect the public safety without abrogation of basic and substantial individual liberty interests. So the legislature, there should be laws everywhere that explain the regulations and restraints and prohibitions. And if it's not, then it wouldn't apply to police powers, constitutionally speaking. All right, we're on to section 341, authority of states and political subdivisions to exercise police power, exercised by governmental branches or departments other than legislature. Okay. Comment note, President's power to seize private property in emergency in absence of statutory authority. Nice. Under proper circumstances, the police power may be exercised by the executive department. Yikes. However, under the federal Constitution, the lawmaking power of Congress is not subject to presidential or military supervision or control. The Attorney General is one of the executive officers of the state who may exercise the police power under proper circumstances. In the exercise of the police power of the state, the legislature may delegate to the Attorney General any such legal, administrative, or executive duties as it deems best and which are not otherwise delegated by the state constitution. Under proper circumstances, the courts may make orders involving exercise of the police power. Generally, however, a court will rarely, if ever, originally exercise a police power, its function being rather to review the exercise of police power by the legislature or an agency which has been delegated the power. So, yeah, a court doesn't like to exercise a police power. And we're down here to the footnotes here, and this one here is Ohio, holding that an executive order directing the Secretary of Commerce to seize the plants of steel companies involved in a labor dispute was invalid as exceeding the constitutional authority of the president. I wonder what kind of plants they were. All right, all humor aside, we'll go to footnote 4 in Florida 1949, holding that the state Supreme Court, as an incident to its inherent power to integrate the bar, may impose a membership fee for the support of bar integration activities. So what kind of bar are they talking about here? A tiki bar? All right, let's proceed here. I know it's been going pretty long. Let's see how long we've been going here. Yeah, we're approaching that hour mark, so this is, I think we're going to leave off on this one on section 342. Indeed. Authority of states and political subdivisions to exercise police powers. Now we're on the delegation of power to private persons, corporations, or public agencies. So we're actually getting to the good stuff now, but this is going to be the final one for tonight, and we're going to be picking up on this on the next one because we're covering a lot of very important things here. I was really hoping to do this one for Memorial Day, but we get started a little bit late. But this is a way of, I guess, acknowledging the sacrifices that many have done for this type of governmental system where we can actually have limits on the police powers, which, as any civilization is going to find, are necessary. But if we're not sure about how they're created, how they're manifested, and how they're regulated, then they can be easily abused, as we see as commonplace these days. All right, let's continue. Since generally the legislature may not delegate its legislative powers to private individuals, associations, or corporations, the legislature lacks authority to delegate the exercise of police powers to a private corporation or private citizen to be used for private purposes as distinguished from a public purpose, particularly where there is no state supervision. Ooh, boy. So that's a pretty long sentence here. I guess we'll read this again. it may not delegate its legislative powers to private individuals, private associations, right? Or corporations. Generally, the legislature may not delegate it. The legislature lacks authority to delegate the exercise of the police powers. Same with its general powers, right? It can't delegate those police powers to private corporations or private citizens to be used for private purposes as distinguished from a public purpose, particularly where there's no state supervision. The police power is so inextricably bound to state sovereignty that it is beyond the power of a state to divest itself of its right and duty in respect of the full exercise of this power, including by delegating police power to a non-sovereign entity. However, a governmental unit does not abdicate its police power by merely contracting with private persons to implement police power functions. So it doesn't lose its police power by doing that. Wherever a legislature has the right to accomplish a certain result, and that result is best attained by means of a corporation, it has the right to create such a corporation, yikes, and to endow it with the powers necessary to effect the desired and lawful purpose. You guys get that? Wherever a legislature has the right to accomplish a certain result, and that result is best attained by means of a corporation, it has the right to create such a corporation. As corporations are a creature of the state, so the legislature should have the right to do that. But then they will endow it with the powers necessary to effect the desired and lawful purpose, to achieve that certain result. Thus, a state may use a private corporation and confer upon it necessary powers to carry into effect police regulations. It may also create a governmental agency for the enforcement of its police powers, but this is only through a legislature. All right, let's look at these footnotes here real quick. Holding that the legislature did not exceed its constitutional authority when it conferred statewide authority on a state college police force. So college police force, that's 2006, Vermont. Then we have Louisville here, involving a contract by the State Department of Highways with a railroad involving use of a highway department funds for the maintenance expense incident to electric warning signals and gates at grade crossings on railroad tracks over public highways. Oh boy, everyone trying to skim them public funds, I guess. All right, and on that we're going to be moving on to the next section on the next one, which will be the authority of federal government. But we did go over all the other powers here that are delegated through legislature, the authority of the states, and the political subdivisions. So I appreciate everyone for coming here tonight. This has been definitely a very educational exploration into the constitutional law, applications of police power, where it comes from, how it's regulated, and how it can be delegated. And by knowing these kinds of things are what are going to allow people to ensure that those powers aren't being abused and they're being used as they were intended to be done for the public welfare. Let me go back to the comments here and see what, great, we got El Perro in the house, welcome. Yeah, the political powers too. And yeah, again, yeah, so I guess you've been, glad you showed up. You've been paying attention here through this. Yeah, if one's presumed to be of the political subdivision, they take it upon themselves to create the corporate presumption. Yeah, the facts. Yeah, the state can't violate individual sovereignty, but it can accept a presumption presented by the municipality for the very use of resident for income tax purposes. Now, again, it seems so, but as we are reading in here, that the taxing authority, the taxing powers and police powers are very distinct. And by knowing those distinctions there, it seems that this may not be as clear as it may seem at first glance. And the conferring of the authority to lower levels allows for greater presumptions. Indeed. And also the fact that you get war powers and police powers. And when you're looking at the different degrees like that, I guess you would have different levels of presumptions too, especially when you get to the higher degree of war power. On that note, I would like to thank everyone for showing up here. Audit them, yes. And you are definitely the boss of auditing out there, keeping them honest out there in the governmental entities. And I just want to remind everyone to please hit the like and make sure you hit that bell notification, get notified of the upcoming streams so that we can have a good conversation here and make sure this information gets out to as many people as possible, especially on this Memorial Day. The best way that we can honor the people that have fallen for protecting the rights and the privileges that we're given here on this country here because of what has been passed on to us, and that we have an obligation to pass on to the posterity, is the whole notion of the liberty and the right of everyone, the inalienable rights to pursue life, liberty, and happiness, and the enjoyment of our property. And the police powers are only there to ensure that that's not interfered with, either by the government or by other types of nuisances that may encroach on those enjoyments that we are supposed to be endowed with by the Creator. So on that, I would like to salute everyone on this Memorial Day, and thank you for showing up, and I'll see you all on the next one. Peace out.